Well, welcome to the Institute of Advanced Legal Studies in London. My name is Carl Stitchen, and I'm the Director of IELTS. It's my pleasure to welcome you to today's seminar, an occasional series brought to you by the Institute. Thank you for joining us. It's my great pleasure today to welcome remotely to the Institute the President of the Law Commission of Canada, Professor Shauna Van Prague. The Law Commission of Canada is an independent agency committed to engaging the people of Canada in the ongoing and dynamic evolution of law. It was established by the Canadian Parliament in 1997 and re-established in 2023 following a 17-year hiatus. The Commission offers leadership and guidance on the responsible and responsive evolution of law in the lives of the people across Canada. Professor Van Prague was chosen to lead this new but not new body by the Canadian government. Her appointment is both, I would say, imaginative and inspired. She is a full professor, now on leave, from McGill University Faculty of Law, where she served since 1993. Her areas of teaching and research include children in law, social diversity in law, legal education, civil liability, comparative legal traditions, and storytelling in law. Her 2022 book, Building Justice, Frank Iacobucci and the Life Cycles of Law, is an exploration of engaged citizenship through law. She has long taken legal education and public engagement seriously as a scholar, making Shauna, in my view, the ideal person to rebuild the Commission. Professor Van Prague will speak today on legal education and law reform, reimagining the relationship at the Law Commission of Canada. She'll speak for about 3/4 of an hour, and questions can be raised by our audience members in the Q&A function at any time. So please do write your questions in the function. I will be monitoring it, and then I will attempt to moderate questions in the discussion period. So with that out of the way, by way of introduction, it's my great pleasure to welcome Shauna. Over to you, Shauna.
Thank you so much. I'm just checking that everyone can hear me. Yes, we're good. Thank you so much, Carl. It's really a delight and a true honor to be here. The last time I was at the Institute was in person in the summer of 2023 to lead an intensive week-long seminar for early career academics in the UK entitled Teaching Tomorrow's Law Teachers, and Carl was a co-teacher with me of that seminar. So I want to start off by talking briefly, and here you'll hear that I have adopted some government speak, talking briefly about the objective, method, and deliverable of that seminar. So the objective was for participants in the program to become institutional leaders in innovation in legal education and to become champions of interdisciplinary pedagogy. Method: participants learned about and practiced a critical active learning approach using a range of models and tools available for introducing, testing, and consolidating complex knowledge. They were placed in a supportive environment and asked to engage with pedagogical philosophy on a theoretical level, to experiment with different forms of pedagogy and practice, and to reflect on their future role as educators. And deliverable: like all successful law classrooms, I would say, the workshop provided space for distinctive and personal narratives, as well as for shared collective analysis. In the last session of the seminar, as participants consolidated and reflected on everything they had learned and shared and read and absorbed and questioned, I shared a brief fragment from an essay I had written back in 2015 entitled Law 8 Days a Week. The diary of a law professor, I had written, can feel full of nothing but blocks of under-inspired teaching, partial learning, best in the circumstances decision-making, adequate reason providing, less than perfect attempts to show respect for another's dignity, messy combinations of self-doubt and stepping up. Perhaps all of that, I wrote, is content and method of a life teaching and writing, creating and connecting, listening and reaching out. So today I return to IELTS, not in person, but from my office. I'm inviting you to downtown Ottawa here, at my office at the Law Commission of Canada, where I have been working for 1.5 years now on recreating, revitalizing, reconstructing, renovating, reviving, resurrecting, I've heard all of these words, mostly reimagining a federal agency not in existence, as Carl mentioned in the introduction, since 2006. So just a very quick review of that timeline. There was something called a Law Reform Commission of Canada, a federal agency established in 1971 that lasted until 1992. Its focus was mostly on revising formal law within Canada's federal jurisdiction, mostly criminal law. Between 1992 and 1997, there was no federal law reform agency. 1997, a new agency with a revised name, the Law Commission of Canada, so note we took reform out of the title, was established with a renewed and broader mandate to consider the changing needs of Canadian society through the study, review, and innovative development of Canada's law and legal systems. Government funding for that commission was withdrawn in 2006, which explains why nothing happened. The commission was essentially defunct for 17 years. And after a parliamentary vote to renew financial support in late 2021, I kind of formally brought the LCC back to life in June 2023. So I started with a little bit about what a diary of a law professor feels like. I am still figuring out what my diary as the president of a law commission feels like. But today I want to suggest that it is no coincidence that I come to the job as a law professor, as did indeed all of my predecessors at the head of Canada's Law Commission, and before that, Law Reform Commission. More concretely, I'm going to aim to share with you, at least in some broad strokes with a few examples, why and how a life teaching and writing, creating and connecting, listening and reaching out turns out to be precisely and perfectly suited to take on the task of conceptualizing, leading, and building an agency committed to engaging the people of Canada in the ongoing and dynamic evolution of law. So in the intensive legal education seminar for early career law teachers, we explored diverse and varied ways in which learning and teaching in law can be understood and experienced. I suggested that we do a disservice to ourselves as teachers and scholars, and indeed to our students, if we settle on fixed notions of how to convey knowledge or how to define lawyerly thinking and analysis. A range of pedagogical techniques, a transdisciplinary sensibility, a constant shaking up of objectives, all of these things bring value to legal education, all encourage an openness to learning and a taking on of responsibility as someone with a law degree. So today I want to claim that the vocation of law reform can be understood to share much with that of legal education. Law reform, too, may benefit from a variety of approaches, techniques, sites, and spaces. It may be identified not solely as the work of explicitly labeled agencies or commissions or institutes, but rather as a shared endeavor across many actors and domains. So now I have a little active learning exercise for all of you to start off that I call Plumbing, Problem Solving, and Poetry. And I'm going to invite you to respond to 2 prompts. So the first prompt, in the realm of legal education, I invite you to make a claim for the central importance of 1, plumbing, and I want those of you with a birthday from January through April to focus on plumbing. 2, problem solving, that's for those of you who have birthdays May through August. And 3, poetry. That's for those of you with birthdays, I think Carl is in there, from September through December. So again, jot down or just write it in your head, or if you're a pencil and paper person like me, jot it down. Kind of a strong claim, or at least some elements of a strong claim for the central importance of your assigned kind of vocation: plumbing, January, April; problem solving, May through August; poetry, September through December. So I'll give you a couple minutes to do that, and then I've got a second prompt for all of you. Okay, so I'm going to assume that you've had a chance to at least jot down a few words or think of a few words. So my second prompt: jurists engaged in law reform are primarily, one, plumbers, and here that's for the September through December people this time. Jurists engaged in law reform are primarily problem solvers. I know that this is the same, but the May through August, you get to keep being problem solvers. Or three, jurists engaged in law reform are primarily poets, and that would be the January through April. So take a couple moments here to make one argument for that statement and one argument against. Now, if you really only want to be for or against, that's okay too. But I invite you to think of an argument for that kind of primary role, and one against that primary role for jurists engaged in law reform. Okay. So I'm going to just invite you to hold on to your ideas and then allow yourself to follow along for the rest of the webinar as we explore how, and you won't be surprised by this, how all of the three Ps, plumbing, problem solving, and poetry, are important and indeed, I think, crucial facets of both legal education and law reform. So very early on as president of the Law Commission, I learned to expect the following observation delivered with a little bit of an attitude: you're an academic. Perhaps because it usually came from individuals involved in the work of law reform across Canada, usually informal provincial law reform institutions, or else from government lawyers involved in policy development or legislative drafting. That observation, you're an academic, sometimes felt a little like an accusation, or perhaps just a statement indicating my limitations or less than full-fledged credentials. Interestingly, however, and a little more optimistically, and over that same early period, the executive director of the country's Professional Association of Practicing Lawyers, when I asked her, why are you happy that the Law Commission of Canada is back? She answered, because the Commission is Canada's thought leader in law. A member of the Supreme Court of Canada, whom I bumped into on the street, downtown Ottawa is a very small place, when I asked, he also said, I'm so happy the Law Commission's back. And I didn't say thank you very much. I said, why? And he said, well, because I'm convinced that the Law Commission of Canada is a unique site of deep and necessary reflection in law. In his article, Law Reform and Legal Education, Uniting Separate Worlds, published in 2008, Michael Coper, at the time Dean of Law at Australian National University, observed that law reform and legal education have traditionally been separate worlds, rarely in danger of collision or even constructive combination. And I think that explains a little bit this repeated kind of, you're an academic, to me. Coper advocated for these two separate worlds to be brought together, and in the article offers some guiding principles, mostly for law schools in Australia in particular, to kind of think about how active law reform and social justice can be understood to be an explicit vocation for legal education. But the title of the text and the position he defends, which I mostly agree with, still underscore this widely accepted assumption that law reform and legal education are distinct domains, rarely interacting or let alone integrated in practice or purpose. And I've thought about this a lot since I started, that this fact of the reemergence of the Law Commission of Canada after a 17-year, what I often refer to as a hibernation, is an opportunity to kind of challenge that assumption and to suggest that legal education and law reform are intertwined by definition and always have been. So let me start by asking how this phenomenon of being shut down for quite a long time, what does that kind of experience promise for the possibility of reimagination, not only of the commission itself, but of this relationship between legal education and law reform? And here I'm going to share with you a little excerpt from one of my president's letters that I have been writing on a monthly basis since I started, imagining that they're being read by 40 million Canadians. We are not quite up to that in terms of readership of our website, but that's how I write them. So this is a letter from this past August. A few weeks ago, I came across a surprising sign on the side of a small fisheries and heritage museum in Cape Breton, Nova Scotia. The sign read, "Closed for innovations." The building was clearly closed. Nothing appeared to be going on behind the shut doors. It would have been more usual, of course, to read "Closed for renovations." Perhaps this is a real possibility. The word innovations was an error, but perhaps it was intentional with a little sense of humor. Either way, the sign, I thought, prompted the question of whether a period of closure, whether partial or complete, can function as an opportunity for innovation. Schools, of course, are meant to be closed for part of each year, giving students and teachers time to shift gears and prepare to return re-energized. Maybe a slowdown or closure or interruption can be, as we hope it is for school-age kids, crucial to creating the curiosity and enthusiasm required for true innovation in thinking and practice. So from that, I take that this idea, closed for innovation, kind of offers this kind of rare opportunity to take a step back, to break the force of habit about law reform agencies, to reconsider what a law reform agency, even with reform out of the title, can or should do and how it justifies its existence. And that kind of constant kind of existential thinking about one's existence and form and vocation should actually resonate with anyone familiar with legal education, right? That we're all kind of attuned to this constant, sometimes self-imposed, sometimes externally imposed existential questioning, even if it doesn't come in the form of explicit discontinuity or being closed down for renovation or innovation. I think this is what Rod MacDonald, the first president of the Law Commission of Canada, who served from 1997 to 2000, was cautioning when he wrote that we should be careful about those who, preoccupied by form and structure, uncritically lament the demise, praise the resurrection, or celebrate the longevity of independent expert law reform agencies. Law reform agencies aimed exclusively at instrumental law reform, Rod MacDonald argues, are not a natural necessity. So I wanted to kind of unpack this and find some sources for thinking about these separate worlds. One of them comes in the recently published book, Inside Modern Law Reform, produced by the Law Commission of England and Wales and just published this past year, 2023. And let me just read this little bit from page 153 for those of you who want to look up the source, where the Commission writes, like the Law Commission, academics are independent, but unlike the Law Commission, which is apolitical, academics' independence means that they are relatively unconstrained in what they can argue or the ways they seek to influence change. They enjoy a free hand, able to advocate reform that is idealistic or prioritizes some policy goals or values over others, or which is provocative or even polemical. By contrast, law reform is most persuasive when it is based on a candid recognition of the merits of competing viewpoints. It would be rare for academic writing to deliver up a definitive answer to the type of complex issues with which we are faced. And obviously, the underlying kind of message there is that that's the Law Commission's job, right? Delivering up a definitive answer to the type of complex issues with which we are faced. It's interesting to kind of put side by side with that kind of strong assertion of this distinction in these worlds and vocations, the work of Yale Law School professor Paul Kahn in his book, The Cultural Study of Law from 1999. Kahn actually takes notice of the tendency of scholars, particularly in the US, but I think we know this phenomenon in the UK, in Canada, in Australia at least, if not in many jurisdictions around the world, a kind of tendency for scholars to think of themselves as law reformers, and indeed to think of the highest kind of ambition of their work to be that of law reform. Legal scholars often frame their papers as proposals for law reform, kind of aimed at courts, as if courts were reading all these law journal articles, or the legislatures. The central assumption, Kahn says, of both the scholar and the lawyer critic is that reform is the appropriate end of scholarship. Paul Kahn vehemently disagrees with that. He says, studying the law, being immersed in law as a scholar, requires something more. It requires that we accept the proposition that there is nothing natural about the legal order, that it is a constructed social world that could be constructed differently. Kahn calls for legal scholars to give up the project of reform and instead seek to bring the legal world to light by asking who we are over and over again and what our world looks like in a culture of law's rules. So this is really interesting, right? A kind of contrasting starting point, but a bit of a convergence with the Inside Modern Law Reform authors kind of proudly constrained more than scholars. And at the same time, right, this observation that scholars often and kind of sadly constrain themselves in order to act proudly as principal law reformers. Both, I think, adopt a quite narrow and limiting idea of law reform itself and what we mean by law reform, and tie it to a usefulness, or, and I think this is language that we're all familiar with. I can talk more about this in the question answer period with reference to a very recently published article called Against Impact by Igor Vensky, just published 2024. Right, this idea that our research and writing is supposed to have concrete, measurable, immediate impact. It's supposed to be useful. So the alternative, I think, to these separate worlds, the insistence that I want to hold on to as an academic now in the world of law reform, is that right, we could maybe be more open to combining the identities and capacities developed within legal education and scholarship, and think more broadly about the work of law reform to open a pathway to some more constructive symbiosis. So for the rest of my time with you, I'm going to kind of embrace and navigate the promise and potential of my 3 Ps. Plumbing, I think, and I will talk about this and give an example for each of these. Plumbing invites us, I think, to pay constant attention to the foundations and frameworks of what we're doing, whether in education or law reform. Problem solving invites us to develop capacities by mapping connections between a broad notion and a deep notion of education and reform. And poetry invites us to make space and structures for inspiration and innovation. So keep your initial responses to my prompts in mind, and I will briefly work through these 3 plumbing problem-solving poetry, offer an idea of what I mean by each of those and how they open up this possibility of rethinking a kind of symbiotic relationship. So let's start with plumbing. And here I think of plumbing as a reference to kind of the foundational pillars, structures, sites of law, where law happens, how it works and changes, and what knowing and identifying and engaging with law can mean. All of this turned into, if you like, an invitation to intentionally think about what we mean by law, whether in a seminar devoted to legal education, so whether we're thinking about how we're going to act and take on responsibility as law professors. I would argue that all of that, all of our choices about pedagogy, purpose, scope, responsibility in law teaching, all is grounded in how we think about law itself. And on the other hand, right, in law reform, and here, again, I'm going to borrow from Rod MacDonald, where he writes, law reform inevitably confronts us with the question of what we consider law to be. Once we adopt a particular conception of law, we must then ask what the notion of reform should embrace in such a context. Third, accepting these understandings of law and reform, right, building from one to the next, begs inquiry into what sort of commission, if any, should be established as the institutional form within which to pursue a law reform mandate. Now, the very first paragraph of Inside Modern Law Reform by the Law Commission of England and Wales arguably does precisely this. And this is the order of things. Starts with, the law, in quotes, is a body of rules made by Parliament, ministers, and the courts. It includes acts of Parliament, regulations, and other instruments made by ministers, individual decisions by public authorities and regulators, statutory orders and guides that decision makers are required to take into account. The law is vast and sprawling, and sometimes unloved and forgotten. It can be extraordinarily complex and sometimes difficult to understand or even find. Governments rarely have the time, energy, focus, or resources to sort it out. Hence, law commissions. So we have, right, a move from defining law to the need for law reform to the shape of a law commission and its job or promise to sort, to organize, to provide clear direction. Now I invite you to listen, as is translated, to Pierre Noreau, a sociologist of law in Montreal. This is from his 2023 book, Le droit, une forme de lien social, so law, a form of kind of social connection. And I think it captures nicely the kind of response or contrast. Law, Pierre Noreau says, is often narrowly defined as the body of laws, regulations, decrees, and rulings that hold authority. However, a sociological perspective offers a much broader notion of law. Concepts such as legal consciousness, legal culture, legal order, legal pluralism have revealed that what we understand as law in legal theory is really just one aspect or perhaps even just a moment of broader normativity. Rod MacDonald, as the first president of the Law Commission of Canada, was very committed to Naurot's kind of idea of legal pluralism, the interaction of normative systems, that he would label law, even or particularly if not state-derived. And we can talk more about this kind of legal pluralist picture, but the idea, right, that and I think most participants will be familiar with this, that law is not only formal state-derived rules, but kind of a messier collection of normative systems in intersecting spaces. So if that's the picture of law, right, that informs the plumbing of law reform, we find a very different imperative for imagining a law commission. And indeed, that, I think, was Rod MacDonald's idea of the Law Commission of Canada. I would indeed go so far as to label him the Law Commission of Canada's principal plumber. And he writes, legal pluralist law reform is the exercise of engaging citizens in dialogue through which they gain richer insight into their normative lives and learn how to manage their everyday interactions with each other. So this process of building a law reform agency led by MacDonald as principal plumber, I think constituted a rejection of becoming a commission dedicated to modifying identified formal written state laws, and instead embraced an ambition to reform law across a spectrum of sites in all kinds of ways, everything, everywhere, and all at once. So lesson learned from 1997 to 2006, that's the Law Commission of Canada's inheritance, if you like, that I take on. But I, of course, have had to embrace and figure out my own identity as plumber for today's Law Commission of Canada. I have had to find and experiment with and share my own framing and foundational words and tools. So I will just briefly gesture at, I think, the key document that shows how I have done that. If you're interested, you can find it on our website. And that's a document entitled Intersections, meant to serve as a kind of foundational framework for the work of my law commission. And I write there, the approach taken by the Law Commission of Canada to law and law reform, open to and grounded in intersection, interaction, and integration, strives to avoid unrealistic or misleading silos, compartmentalization, and insularity, whether substantive, institutional, jurisdictional, or tradition-based. It acknowledges and embraces the intersection of law's substantive realms and subjects, the interaction of institutional structures of law, the integration of legal traditions and jurisdictions, and the interweaving of concepts found in and beyond law's disciplinary domain. The Law Commission itself, I have written, can be understood through the metaphor of intersection. Like law, it, the Commission, may take on the role of crossing guard, assisting others across the intersection in following a meaningful trajectory. As a site of intersection, the Commission serves as meeting place and reference point on the dynamic map of law and justice in Canada. It provides space for the intersections of research, reflection, and reform, and its work intersects with that done within the distinctive spheres of legal practice, legal education, policy making, regulation, litigation, and judicial decision making. So as I leave plumbing, I want to, I guess, underscore that I think of plumbing not so much about skills and tools, but rather about grounding the work in carefully designed and installed structures, the same way I would do as a law teacher, and now as the leader, or as I say, principal plumber of the Reimagined Law Commission. So now let me move briefly to problem solving and then to poetry. So problem solving. Problem solving, I think, is the one that sounds kind of most expected, right? In the world of legal education, we're familiar with reference to problem solving as something that students should learn and should aspire to be able to do. The knowledge that comes with studying law is meant to go hand in hand with the development of a capacity to put that knowledge to use, right? To be practical, on the ground lawyers, to ensure that that knowledge has real impact in resolving a conflict, for example, or in drafting regulations. And many law teachers talk about adopting problem solving as a pedagogical technique. So as a law teacher coming to the Law Commission, I wasn't really surprised to find problem solving kind of central to how law reform is understood and assessed. The language of reform appears to assume the need for repair, a call to fix, the power to direct change and have a concrete impact right away on a particular area of law and on people's lives. The articulation of recommendations, typically to government, is associated with the demands and activities of the work of jurists associated with law reform. Topics for study may be chosen based on identified problems, and the success of a law reform agency may be evaluated on how well it responds to and comes up with solutions to those problems. And even further, it can be assessed on kind of figuring out whether those solutions were indeed implemented by the people in power. Now, all of that, I think, sits probably somewhat awkwardly with how I just introduced a notion of thinking about law in through a legal pluralist lens and thinking about the role of the Law Commission. It calls, I think, for a little bit of a rethink, not a throwing out, because I think the notion of problem solving is actually important, but a bit of a rethink of it and a rethink of its companion, if you like, measurable impact. And I think that we can more generously understand problem solving as a kind of directive to pay attention to context, to think about how the landscape of Canadian society and problems within Canadian society keep shifting and changing over time. In our first publication of the Law Commission, a reflection paper called Recall to Reimagine, I wrote that resituating the Law Commission is a task of positioning the agency in time. The Law Commission of '97 looked ahead to the end of the 20th century. Today's commission finds itself on the cusp of the second quarter of the 21st. And so it's important, and I write to articulate some of the elements that will be relevant to law reform that come with this moment. And so I think that this is actually a kind of problem-solving kind of approach, but without the promise of figuring out short-term solutions, right? So a tentative list of those elements in Canada, at least, includes an appreciation for learning from Indigenous communities, narratives, and legal traditions. And then, and these will sound more familiar, I think, to people in any jurisdiction, significant displacement of peoples around the world, destructive distrust of facts and fact-finding, the need for complex understanding, and I think desire for empowerment on the part of youth. So all things that in the face of uncertainty, right? All things that we're kind of familiar with. But I want to take a moment here to explore this first element, learning from Indigenous communities, because I think that this might lead to some fresh and innovative ways to trace problem solving, if you like, at the interface of legal education and law reform. First, John Borrows, Canada's leading Indigenous law scholar and author of a 2006 report to the Law Commission of Canada on Indigenous legal traditions, reminds us that reforming with attention to Indigenous law requires studying the nature, sources, and limits of knowledge as articulated by Indigenous peoples themselves, and understanding that Indigenous peoples create and justify what they think they know to be true in their own terms. So rather than asserting a leading role, the Law Commission becomes a student, if you like, of Indigenous knowledge and law. But I also want to, and here I'm borrowing from an excerpt from my book, Building Justice, that Carl mentioned in the introduction. I want to actually share very briefly a kind of surprising example of what I think counts as impact of a law reform agency by looking at a classroom. This isn't usually how we measure impact, by the way, of what law commissions do. But here's the example. In the fall of 2001, my first-year students in tort law began their study of law by learning about the experiences and claims of survivors of Canada's Indian residential schools. I invited them to reflect on the human needs that may result from wrongfully caused injury by reading excerpts of the Law Commission of Canada's first report entitled Restoring Dignity, Responding to Child Abuse in Canadian Institutions, published just the year before 2000. For most of the students at the time, and this has really changed in the almost 25 years since, this was the first time they had heard anything about residential schools. Every September since, from 2001 through to 2022, I welcomed students to law school in the same way. The first thing they read as law students is a Law Commission of Canada report. In that report, the Commission lists 8 types of survivors' needs. You can take a look at the report if you're interested in those, but they include acknowledgement, accountability, financial compensation, public awareness. And then I divide the class into 5 groups, each with the job of thinking about a distinctive form of response in Canadian law and society that they haven't studied yet, but they still have a vague idea about. And I ask each group to think about how their assigned form, and the forms are Truth and Reconciliation Commission, a formal government apology, criminal justice, civil liability, community-based initiatives, right? How does each form respond to the needs? And then we compare and contrast what they think they know. Over the years, of course, things have changed in the Canadian landscape, and so we add in material. Now we have a Canadian Truth and Reconciliation Commission. Back in 2001, they had to think about South Africa or Cambodia to think about the possibility of such a process. We've had formal apologies. Now they can think about whether there should be more in the way of apology. And I also ask them to listen in a way that wouldn't have been possible before, the gathering of voices and stories from survivors, to listen to actual like little excerpts from people talking about their experience in the residential schools. So the classroom exercise here that I'm sharing with you just briefly is, I think, a surprising example of how to think about the use of and impact of a Law Commission report. Indeed, in my book, I suggest that Restoring Dignity, the report, helps us think about elements of learning in law that are absolutely crucial throughout legal education: humility, self-knowledge and responsibility. Responsibility. Students are invited to realize that they will often act as jurists not as problem solvers, but rather as problem participants, builders in solutions, team members, dreamers, and burden carriers. And I suggest that this range of sources and mechanisms with which law students and jurists have to be familiar in law should feel daunting. It's a heavy obligation to work with them. Legal education should lead to that kind of taking on of heavy responsibility. And if we think about it, if law students can start their legal education immersed in and inspired by a Law Commission report, then perhaps repeating the story of that inspiration, as I've just done, can provide a concrete indicator of law reform's problem-solving impact. I'm watching the time. Poetry was always going to be the shortest, so I'm going to just briefly move to poetry and some brief references to what I think is actually the centrality of poetry in both legal education and law reform. So 3.5 decades ago, almost 3.5 decades ago, as a doctoral student in law at Columbia University, where I was actually with Carl, I asked the Dean of Graduate Studies if it would be all right if I enrolled in a poetry writing workshop in the creative writing program at the university as part of my doctoral program. And I've never forgotten the generosity and openness of that Dean of Graduate Studies, who said, of course, that sounds like it's perfectly suited to your work as a doctoral student in law. And the message from the poet, who was in his 80s, who ran the workshop, to each one of us as participants was, find your voice. Now, if a poetry workshop can be part of a doctoral student's path and a path to a life in law teaching, then perhaps poetry as aspiration can be part of a law commission's agenda. As I started off, I put on my poetry hat a little bit to come up with a triptych of a 3-part mission or raison d'etre for the Law Commission: living law, pursuing justice, renewing hope. Kind of poetic, and inspired a little bit actually, and I love to share this wherever I can, inspired by something that American law professor and scholar Robert Cover used to say: I went to law school to make the world a safer place for poetry. But here in the last couple of minutes, I actually want to suggest that poetry is not just about finding some good words, but it's also about shape and rhythm. It's probably true that a Law Commission of Canada president can't just start writing poems and getting them out there as the product or deliverable of the commission. But what she can do is think about the shape of our work and the rhythm of it. And in that, I was looking from the beginning for an image or metaphor, and I found it in the kite metaphor offered by Werner Menski in his piece, Flying Kites in a Global Sky, New Models of Jurisprudence. For those of you who don't know it, I highly recommend this piece, published in 2011, where Menski suggests that law always needs to be navigated between 4 corners in tension. He would put at the top natural law or ethics and values. On the right-hand side, sociocultural and socioeconomic norms. On the left-hand side, state law and its various rules. And in the bottom corner, international law and various forms of human rights. In the last session of the legal education seminar at IELTS in the summer of 2023, we used Menski's kite metaphor as a catalyst for creativity and collaboration. Participants, all emerging law teachers in the UK, were given the opportunity to craft their own kites using construction paper, crayons, stickers, and other materials. And that exercise has continued to inspire me ever since. Menski asks readers to consider a kite for engagement with and navigation of law or legal theory. But the early career law teachers have gone off to their classrooms with their fists holding tight to the string of their kite, with a little bit of Mary Poppins magic in the mix. So why not invite every graduating law student to head off with their own metaphorical kite? Why not encourage scholars to develop their unique kite of research and teaching? Why not provide guidance for contributors to law reform by requiring any substantive law reform project to fly its own kite? And indeed, we are busy creating a template for all of our contributing authors to the commission that takes on this kite metaphor, with a corner for transdisciplinary approach, a corner for transnational or comparative and international law, a corner for transversal, moving from the empirical to analysis to recommendations, and a corner for what I would call transsystemic, an acknowledgement of coexisting traditions and systems and jurisdictions in Canadian law. I think we can use this kite to foster bold and original thinking in every project of law reform, to highlight what Menski calls the intrinsic and dynamic connections between different aspects of law and life. I've also taken inspiration from this kite metaphor to hold together 4 distinct yet overlapping vocations for all of our projects, whether in research or engagement. And here there is a little bit of rhyme so that it does sound a little poetic. These 4 corners or 4 vocations are dream, repair, build, and share. The idea that the Commission's work anticipates and plays some role perhaps in influencing future directions, so over the horizon thinking. Repair, the role that we have in identifying areas where structures or practices appear to be broken, where a restart may be needed. Build, the role we play in strengthening connections or forging links across spheres, including research, practice, policymaking, regulation. And share, the idea that the Commission can contribute to meaningful legal literacy and enrichment of legal knowledge. Okay, so if we were actually all together in a physical space and classroom, I might actually ask you to turn to your neighbor with your initial responses to my PPP exercise and kind of test them out, right? Modify them in dialogue with the person sitting next to you, and push you a little bit more to think through, maybe now, maybe later, about think through your own identity as plumber, problem solver, and poet without choosing any one, right? With actually taking them all on as teacher, scholar, ongoing student, and reformer. And of course, it was a little unfair of me to prompt you to ask for the primary vocation or their centrality. I actually want to suggest that each one can be characterized as the most important. Perhaps all of this discussion and the melding or intertwining of legal education and law reform is all kind of a form of self-justification for the job that I have at the moment. But I think it's also key to paving the way for the Commission to becoming part of the furniture of Canadian law and society without ever becoming the old dusty sofa that nobody wants in the corner of the room. How the LCC has so far sought to reconsider what a law reform agency can or should do and how it understands the value of its existence is an unfolding story. By sharing it early on, I hope that our experience can stimulate discussion and further reflection. And I actually am adding this kind of discussion and a self-inquiry. I see this as a mode shared by the Law Commission of England and Wales, which I think it's very unusual actually to issue something like the book that they published this past year, Inside Modern Law Reform, to kind of invite people in, if you like, to the work. James Boyd White in Schooling Expectations shares an address to graduating law students. And I want to suggest that we can imagine that speech being made to tomorrow's law reformers, or maybe also today's law reformers, explicitly identified and named as such. This is what he says. What do you see as you look forward to the next 2 or 5 or 20 years? I cannot speak for you. You each have your own imaginings. Neither you nor I can know what your life and practice will really be like. But I am confident that it will be different from whatever you imagine. You will become an educator. This may in fact be your most important and meaningful role. Having been taught, you will teach. This is a life full of promise, uncertainty, hope, and challenge. I have asked many questions since I started this job as president of the Law Commission of Canada. I have been asked many questions too, and I think I will still be grappling with all those questions at the end of my 5-year mandate. I'm going to just conclude by underscoring the impermanence and imperfection of both sites, beautiful as they may be, of legal education and law reform. And here I will do that with a final excerpt from one of my letters, this one from June of 2024, marking the first anniversary of starting up the commission. And this is what I wrote. In an article entitled Two Standards of Repair, Restoration, and Resilience, Eric Encarnacion referred to the Japanese practice of kintsugi to suggest an inspiring approach to repair. Shattered ceramics, he writes, usually show cracks, even when the shards are glued back together. So discarding them is tempting, but a Japanese practice called kintsugi counsels a different response. Reassemble the shards, using adhesive infused with gold dust. The results are stunning, with the cracks glowing like lightning, giving ceramic ware new life. Kintsugi turns a lamentable event, someone's having dropped some pottery, into an opportunity for artwork, a blessing in disguise. And now my words. To date, I have heard many words starting with RE used to describe the task of leading this Law Commission of Canada. I've already shared some of them with you. Recreation, restart, restoration, renovation, resurrection, resuscitation, renaissance. All are situated along a broad spectrum of meaning and imagery. The notion of kintsugi invites us to add resilient repair to that vocabulary. Perhaps the 17-year gap in the existence of the Law Commission is an invitation to fill the cracks with gold dust, to rejoice in the opportunity for artwork, to find a blessing in disguise. So I will stop there. I know I've gone over my 3/4 of an hour, but thank you for your patience, and I look forward to any comments or questions. Thanks.
Thank you so much, Shauna, for a really inspiring talk. Fantastic. Kind of introduction to the Law Commission for those who might not be familiar with it, but also a wonderful talk on legal education and its relationship to law reform. We certainly welcome questions and comments in the Q&A function, which I will moderate, but I've got plenty of notes and questions to get us going. And
I saw you taking notes, Carl.
I was taking lots of notes. I want to start with. I confess I hadn't read the Law Commission of England and Wales report, but I thought your quotation about law reform and legal academics was really interesting, and how it connects to Khan. It's a remarkably romantic notion, I thought, coming out of the Law Commission about the role of academics. And I mean, perhaps I'm being cynical, but I thought, but we constrain ourselves all the time. We constrain ourselves for reasons of professional standing, of success, of not being seen as mad, whatever it might be. So it's interesting to see kind of how on the outside the inside is viewed, and of course you're trying to bridge that inside out dichotomy.
Yes. No, it's really interesting, because as I read that, I think, wow, I actually wish academics thought that they were relatively unconstrained, have a free hand, can be idealistic, it can engage in, kind of a broader notion of social justice. I think Khan is exactly right in his critique that most of us do it in such a tedious and dull and kind of pointless way. So many law journal articles, and so many of the ways in which I think students are told that this is the kind of format that is a serious piece in legal writing. It must identify a problem, and then you either identify a case or you identify a piece of legislation, and then you make an argument for making a change in the piece of legislation or for telling the judge what they should do the next time, knowing all along that no one's actually going to read this and it's actually going to have no impact. But this is the kind of the way in which you fulfill kind of your responsibility as a serious academic. So I had actually, I think Carl knows this, I had spent my whole career as a legal scholar not writing pieces like that. I'm kind of wondering why everybody wanted to do that. So you're right, like it is kind of opens up a space that you would kind of wish academics would take up. On the other hand, a little bit sad in the Law Commission saying, but they must be all having fun doing that. And I think that is part of what's behind the "you're an academic" said to me too. It's not that you're an academic and how horrible. It's you're an academic, you're so lucky, you've been doing something that is, that isn't kind of the serious drudge work of what we all do in law reform. And so you now are not going to get, what the proper constraints are of this job. And the kinds of ideas that you have are all very nice, and just give it a little time, because you will realize that they're kind of pointless, and you will give up on them. And so they're an interesting tension. And I think, right, I would take Khan's encouragement to scholars to think more broadly, to kind of say, and why not back to the people in law reform? Like, one of the, I didn't talk about this, but from the start, I initiated a kind of series of roundtables and meetings that I've labeled the Listen and Learn series, of trying to move across this country. That takes a very long time in this country. Actually, I had kind of hoped to do it all in 1 year, and now I'm hoping that I will have gotten to every province and territory by the end of 3 years. But trying to listen to what people think a law commission could be doing, what kinds of priorities we might have, what kinds of projects we might take on, what kinds of possibilities are out there, what kinds of preoccupations do people have about the future. And one of the saddest encounters was with a professor, I won't say which faculty of law, who at the round table proceeded to tell me all about an article that they had just published, where they made an argument that the word should be replaced by should, and that would make all the difference in this area of law. And they were sharing this with us so that we could we please take on that project of this particular scholar and take that to the Minister of Justice and put it on the legislative agenda for the Government of Canada. And it was embarrassing and kind of sad, because I had to reply, well, you do understand that the Law Commission of Canada has no power. I don't put things on a legislative agenda. I don't have some magic wand to take your idea about a piece of legislation and somehow get it to government. And you could just see that this person could have been kind of disappointed. But they had written this whole article saying, change this word and it will make all the difference. So finally, maybe, they had met someone who could take their law journal article and take it to the powers that be, right? And it just, in my view, kind of all wrong on so many fronts, and bound to be disappointing, right? If that's how we think about what the point of the commission is, and frankly, bound to end in being shut down again. Now, I may be shut down at any moment, which I get reminded about every single day in the capital city of Canada, like all the time. People actually say to me in a kind of patronizing way, did you know that the government might change? And maybe the Law Commission will be defunded again. And I always say, oh, no, I had no idea. Are we having elections? Arguably, a Law Commission should be shut down if that's all it can think of doing, right? So interesting. And I think the Law Commission of England and Wales kind of doesn't do itself as great a service as it could in terms of showing how creative and in some ways unconstrained it actually is in coming up with topics and coming up with really interesting and innovative approaches to things that matter in England.
So I'm going to give you first a question which I'm sure you've heard before, but I think it's a valid question. I'll condense it a little bit, which is really saying, isn't law reform essentially practical? And shouldn't what the commission do is to focus on the drafting of the work of drafting legislation, essentially?
Yeah. So some of our provincial agencies would characterize their projects some of their projects at least, as kind of drafting model, model pieces of legislation or suggesting changes to existing, modernizing kind of archaic legislation, etc. That is definitely how the Law Reform Commission of Canada from the early 70s to early 1990s operated. Now, what has been interesting to me, putting aside whether we should or shouldn't do this, is that the Law Reform Commission was funded at a rate of 5 times what I'm funded at. So it had a much bigger in-house capacity. It had full-time commissioners. I don't have that. So the Law Commission of Canada, when recreated in 1997, was recreated in this mode where the actual team on the ground is really small. It's me. I'm the only commissioner with a full-time job, with a team, and this counts. This is everyone from my executive director, a kind of accountant, researchers, administrative people, or 10 people. So the work, in a sense, like we can't imagine the office of the Law Commission of Canada as a place that brings together the expertise and ability to sit down and work on redrafting of legislation. That isn't to say that, and that I would disagree with this idea of the practicality of law reform. And in fact, our very first major collaborative project was identified along these lines. It's a project on charity and charitable organizations in Canada. It brings together authors across a range of domains of law. It brings scholarly practitioners into the mix of contributors on various topics. And we hope through engagement activities and possibilities of kind of reading these pieces as they are written for us and put together in an overall report, that through that engagement, they will find their way into the hands of people who can indeed make a difference in terms of, sometimes it's not so much writing a different rule, but the discretionary practices, let's say, of the Canada Revenue Agency officials in terms of defining charitable purpose for in tax law. So it may not be the written rules that are the problem, but rather kind of identifying how in practice things are going on. So I think my answer kind of is kind of a multifaceted kind of taking into account of the pieces I have to work with. My budget is actually half of what the Law Commission of Canada between 1997 and 2006 worked with, and as I say, a fifth of what the Law Reform Commission before that worked with. So I need to be creative about how to work with the Academy actually in commissioning pieces that the other weird thing is I wasn't given what is called grants and contributions power. So I can't write checks for things. I have to come up, and it's taken us months actually. Here I'm getting into bureaucratic niceties that I don't think anyone's interested in, but it's all kind of combined, intertwined with how you think about the work. It's taken months to figure out how we can give out $10,000, so roughly, what is that, £6,000 kind of stipends to our scholarly authors for a 10,000 word short paper or report. So we're only able to start that mechanism of getting people to do what I do think is the practical work of law reform. It's true, we're not, and I can't respond to the needs of Canadians and Canadian society just by turning us into a think tank. And at the same time, I think we deeply need to foster and work with the connections to the Academy. And I'll just finish with the primary reason given in 2006 by the government of the day for defunding the Law Commission, interestingly, was that they said we don't need another body that does drafting. We have hundreds, thousands of drafters in the Department of Justice. So there is no need for an independent agency that's going to do that work or try to do that work when they actually don't have the expertise to do it. So I'm also have that in mind as I think through the vocation and the actual projects that we take on.
And it would
Sorry,
be
I will
remiss.
make my answers shorter,
That's
Carl.
fine. It would be remiss of me not to mention that the Institute is the home of the Center for Legislative Studies, where the center director would, I know, argue that they have tried to understand the study of legislation and the drafting of legislation, not simply as a craft, but also as an academic subject, and indeed a subject that can be theorized. So I think
Right.
it's got interesting how we
Mm.
construct things as art or science or
Mhm.
craft or practical or theoretical is
Mhm.
all
Mhm.
contingent.
I'll
Now,
also, could I just add in there on the, when I talk about, it's interesting, when I talk about plumbing, and I know that there's other, I know that the plumbing language and the problem solving language and even the poetry, none of it is original. It's not me using these terms for the first time. But I think often people think I must mean that plumbing is somehow lower down than poetry, like that I want to get to the poetry. That's where I have the most fun. I actually think I've had the most fun actually in what I think is the plumbing, the kind of the now, it's words, it's not pipes, but using words to come up with foundational kind of structures, as I've suggested. So that's also practical, I think.
well, indeed, I would say that you've spent the last year and a half, and I should say that when I last saw you, and you had just been very recently appointed and taken up the post, you were walking around with a notebook, um, making notes about what a strategy would be. I noticed the notebook was largely blank pages at that point. So, in a
I now
sense,
have 7 of those notebooks filled up.
as a plumber, I mean, this was a case of
Yeah,
it was a set of found literally a shell.
yeah. There
So
was
you had to
nothing.
put the plumbing in from scratch.
Yeah.
Now, this will not surprise you who this is. I'll tell you who it's from at the outset, but you would have guessed anyway. This is from Ashley, who was
Oh, nice.
in the summer course a couple of years ago. It will come as no surprise that I found this talk incredibly interesting and inspiring. Thank you, Shauna. I'm so happy that you are in this role at the Law Commission of Canada. I don't have a question, but want to share how much I love the idea of jurists and legal educators as poets. One of the major takeaways for me from last summer's IELTS workshop was how much inspiration matters. I've tried to accept that invitation to let in the poetry and the beauty, the metaphor, the creativity in law and legal education. I try to channel this into my teaching and my research in order to create opportunities for inspiration, for students to feel inspired by an idea, by the beauty of a sentence, by a judge's take on an issue, etc. If only the research excellence framework, which of course we work with in the UK, rewarded inspiration instead of impact. Thank you. That's from Ashley.
Oh, well, that's lovely, Ashley. It's lovely to imagine your voice. And of course, now I must say that the kite making exercise was directed by Ashley in the context of that seminar, who brought along all the arts and crafts supplies, and was responsible for, I think, a lovely concrete piece of inspiration that participants took with them. Well, thank you for taking the time to write all that, and lovely to imagine seeing you. And the UK is lucky to have a great Canadian as a law teacher with you in Ashley.
Here's a question about Indigenous law and legal knowledge from Susan Bro, who works with us at the Institute. I was fortunate to be involved in the launch of the world's first Indigenous law degree at University of Victoria and work with John Burroughs. But I detected resistance to incorporating Indigenous ways of knowing to the Canadian legal system. Are you encountering such resistance? I hope not, because even in the UK, there is an acknowledgement, I'd say in some quarters, Susan, there is an acknowledgement that in the decolonization of law, Indigenous knowledge is essential.
Yeah. So that's interesting. I mean, I think there is some resistance still. I don't think anybody would say, oh, no, there's no resistance to keep kind of thinking about and confronting. I was just out to Victoria late September and talking with the folks at the Indigenous Law Research Unit there, who are just doing some amazingly creative and innovative things. I think that the challenge now is actually, and Indigenous communities are finding this, and people working with Indigenous legal traditions and legal knowledge are finding this. What difference does it make? What does it actually make on what does it mean on the ground, whether you're working with this as a provincial court judge or working with it as a legislator or someone planning for emergency preparedness in this country, right? A climate produced emergency preparedness. What does it mean to take into account not just the existence of Indigenous communities, but the teachings from Indigenous knowledge and the approaches to norms and practices? And that, I think, and John Borrows is on my advisory council. I've had interesting conversations with him about how we shouldn't avoid that kind of questioning. So I think often when people immersed in Indigenous traditions and knowledge hear someone say, well, what difference does that make? Or what do you do with that? Or why are you doing that? What is integrating these legal traditions going to mean? We'll often hear that as a wall being put up, right? A resistance, a kind of saying that that's not worthwhile work. John Borrows and I have had interesting conversations about how instead we can turn that around and welcome the questioning, saying that's fair enough questioning. We don't need to unpack where it's coming from. It might come from different places, but let's try to find some ways to model responding to that question. So one of the things we're trying not to do, I mentioned briefly, is kind of say, yay, the law commission's here. We're going to explain to everyone what Indigenous law is. That's off the table because different research units, Indigenous communities themselves are doing that work. So we're planning to try to open up, this is just a small thing, but John Borrows interestingly thought it was a really important thing, open up space on our website to showcase law reform initiative within Indigenous communities or legal traditions, so that becomes part of how the world, particularly from the UK, for example, interested in law reform in Canada, and they come to the Law Commission of Canada and they see that we've got all this space to highlight, if you want to understand law reform in this country, it's not all at the level of the federal government and the rules or even what the Law Commission is doing. Look at what the Anishinaabe Nation Council in this particular region is doing. Look at what an Indigenous Law Research Unit at a university is doing. Look at what a particular nation, Haida Nation, for example, is doing. Those are examples of law reform. So that's one of the things that we're planning to do in terms of Indigenous engagement. And the other is to try to find some spaces where we can kind of support hard conversations about how to incorporate evidence from Indigenous law into a criminal trial, for example. There's no set answer to that, but there are models because judges are having to do it, and they often feel that they don't have a lot of guidance. So a partial answer, but a really important question.
Now, I wanted to ask you about kind of impact. This is going to be a very poorly formed question, but you've talked about public engagement, and I wanted to ask about the role of lived experience and the prioritization of lived experience, which I think is relevant to your metaphor of the intersection. Mm-hmm. Because I do worry sometimes that we live in a world, and it's true around law. It certainly has been. We've talked about this many years ago around legal education, with a kind of which experiences a kind of fetishization of lived experience, which actually makes me worry about whether an intersection suggests crossings, suggests kind of an openness to engagement. And I do wonder whether we're in a world where there's a danger of lived experience as this kind of trump card that shuts things down rather than opens things up when it comes to law.
Yeah, no, really interesting. Something also front of mind, although I have so many things front of mind that I might just topple over. But from the start, yes, some people said, oh, you can't move forward on any project. You can't pick anything until you do surveys, right? Because you actually have to draw on lived experience before you can identify anything that the Law Commission can do. And maybe I was just being grumpy at the time and looking around and realizing I had no capacity to do any such thing. But I said, you know what? I'm not going to do that. I'm going to count on organizations who have, as part of what they do, they work with people. So we're meeting with them. Like if I'm not just meeting academics across the country, I'm meeting with representatives of grassroots organizations who work with people, right? Who can kind of identify key issues intersecting with law or legal actors that have an impact. So I can kind of accumulate those, but that I don't want to pretend that a Law Commission of Canada is actually a kind of, you know, an outfit where we're literally kind of opening the door to the Canadian public coming in and telling us about the things that are going on in their lives. Now, does that mean I think actually there should be spaces for Canadians to be doing that? If asked, I would say, I don't know why we don't have the equivalent of, walk-in medical clinics. We should have walk-in legal clinic. Lots of people are working on this stuff, though. When I talk to people in the access to justice world here, I talk to people who are working on mental health and law. A lot of that work, kind of responding to experience and needs in people's lives, is happening. And I am very cautious about duplication, let alone stepping on toes. I mean, we did one reaching out to a high school kind of education module this past year that was really all focused on coexistence of legal traditions in Canada and helping teenagers understand that. And interestingly, kind of got wrapped on the knuckles by a group that does high school outreach and legal literacy out in Vancouver, because they said that you don't know what you're doing when you do that. We do high school. Like let other people do high school outreach. And I said, but I'm not going to high schools to talk to them about their rights. It was about kind of how to understand the legal landscape of Canada. So I'm not going to worry about that, but I'm going to try to carve out a vocation for the Commission that is careful about promising to kind of be the immediate kind of interlocutor with Canadians, because we would fail at that. So it would be kind of silly to promise it or to kind of try to gather through surveys and then kind of, shape what we do based on how people understand law in their lives. I'd actually like to do more of the teaching, not in a responsive way, but the teaching to help people understand in ways that are meaningful for their own participation and potential for making a difference in their own lives and the lives around them. But they often need to actually have a better sense of, and a more sophisticated sense of how law works. I just heard last week from a senator here that many people in the Senate and many members of Parliament actually, fewer and fewer have gone to law school, which is fine, good thing, nice, more diverse group of people. But that actually means that people have a very limited idea of what law is. And it's no surprise they think that law is in their hands. It's all about legislation and rules that tell us what to do or what not to do. And no kidding, as we kind of, should have known all along, most people don't live their lives kind of governed only by, particularly in Canada, federally kind of driven or sourced rules about how to operate in their daily interactions. So again, my answer just indicates potential for more conversation, but something that I've also been thinking about.
I'm going to pull two questions together from the audience, and then there's one further question, and then I think our time will definitely be up. So the first one is really just about kind of how you engage with legal practitioners. Do you commission? Do they engage with you? And the other question is about how the relationship is evolving and will evolve, how you envision it evolving with legal educators and students. So kind of a question, to use bureaucratic language, it's a question about stakeholders.
Mm-hmm. Mm-hmm. Yeah, so early on, we, of course, tried to pay some close attention to what we could learn from the history of the Law Commission and whether they had done enough in terms of ensuring friends and stakeholders. So one of the first stakeholders I reached out to was the Canadian Bar Association. They've been remarkably positive. I think we can do more with legal practitioners. They're going through a change in leadership. I think the Bar Association itself is going through an intense kind of self-analysis and inquiry into what it does and how it serves legal professionals across this country, because we don't have a unified bar, right? We don't have one professional association. So we're also meeting with, whenever I go to a different province, I'm meeting with the people who run the particular law societies, so the bar in each province. And when I get to the territories, with the territories, to see what they're thinking about, concerned about, whether we can make some connections to the practice. It's tricky. There too, a little story. Before I started, my best friend from law school, who was like my closest friend, said to me, "Well, congratulations, but honestly, what difference do you make to any of us in legal practice? I couldn't care less about the Law Commission of Canada." I thought, well, you could pretend to, since I'm your friend from law school. But it was a really important insight to me that for most practitioners, they're not seeing the connection, which again is partly why we started with the Charity and Law Project, thinking that we will have some potential to reach out, we hope, to practitioners. And we're also working with something called the Canadian Institute for the Administration of Justice, which is mostly kind of a conference organizing central outfit in Canada that brings practitioners together, and we're kind of partnering with them on some of their activities, and working very hard to make and sustain connections with faculties of law across the country. This is where I'm finding that 30 years as an academic in Canada means that any faculty of law I turn up in, and this is really a lovely part of the job, I know many or most of the members of the faculty, so I can really talk to them about what their projects are, engage with them, kind of try very hard to get the Law Commission of Canada back on their radar. But all of this is, takes some time. So, building those relationships doesn't happen overnight, and I think it will happen through our outreach and engagement efforts as well, to ensure that we're kind of facilitating ongoing conversations about our projects, not just kind of spewing out or producing research reports that then sit on a shelf or get directed to a very narrow readership.
And finally, some very positive points in this comment, and a really challenging question to end on. So, beginning, I wanted to say it was refreshing to hear someone involved with the Law Commission to talk about law in terms of wider normativity beyond state-derived legal rules. So, hurrah. But drawing on the earlier question about Indigenous law, I'm wondering, if I may, to what extent your idea of normativity extends to the more than human world, whether that be animal law, plant law, or viral normativity, given the effects of COVID. This idea of non-human normativity is certainly something that's quite cogent within Aboriginal legal theory. Do you think legal practitioners can learn anything from the more than human world or non-human normativity? Briefly, what's your answer?
Okay, so my answer is that I love getting a question like this because, again, right from the start, this was one of the things that I actually floated with people I was talking with about. Actually, Carl, you'll remember I talked to you about using the notion of borders as a way to kind of organize some of our research. And in my mind, I was thinking of the borders between human and non-human, whether in the AI world or drawing on Indigenous teachings and experience, the kind of human and non-human living world. And you take it even further to kind of understanding viruses, bacteria, etc. So I get it. This was the kind of thing that people just looked at me and said, "Oh, you are such an academic," right? As if, and to me, it actually ties in with the question just before. How do we actually do some of this work of connecting the people who think that they're in practice, and therefore when they hear this kind of question, they go, that has nothing to do with practice. How do we get the practitioner people to realize actually it has everything to do with practice, right? That those kinds of questions are the beyond, they're actually going on today, but they are clearly the beyond tomorrow questions, and we need to be thinking about them and, as you suggest, learning from people who've, and here I think of Lindsay Burrows. Yes, a relation to John Burrows, his daughter, who now teaches at Queen's, who has been doing some of this work about identifying the webs of norms and laws in our lives and thinking beyond the human to rivers, right? We know this, to rivers and to animals, to the beings with which we coexist in the world. I don't have a more concrete answer. It's something that I may not actually get to kind of put on my agenda in my 5-year mandate, but I really appreciate the question and the reminder, and a realization that I'm not alone in thinking that that if you're serious about law and law reform and imagination for the future about law in our lives, that questions like these have to be floated and out there and part of the conversation. So thank you.
Well, that seems a fantastic note to end tonight's seminar. But before we close, I do want to thank, I'm going to say Shauna rather than Professor Van Praag, Shauna, for taking the time out of her busy schedule. No, there's lots of travel, lots of meeting people. So we're really grateful to have you join us today, for sharing with us, as an international audience, the journey on which you've embarked with the Commission. And thank you as well to our audience for joining us and for your participation. So until you're next with us at the Institute, whether online or in person, it's goodbye from us at ISLES. Bye-bye.